Welcome to Essential Contracts Every Founder Needs. Verbal agreements often cost you when you can least afford it. This video will cover the core legal agreements every founder needs, what they protect, and how to get them without spending a fortune on lawyers. This program is brought to you by the Series of Thoughts team. This episode is part of the Legal Foundation module within the Starting Your Company course. This course covers everything from validating your idea to scaling your business. Module 02, Legal Foundation, includes 5 episodes. Today, we focus on Episode 5, Essential Contracts Every Founder Needs. This builds upon previous episodes covering business structures, incorporation, finances, and protecting intellectual property. Why can't legal foundations wait? Early-stage founders often skip contracts thinking they are bureaucratic or a sign of distrust. The hard truth is, something always goes wrong. A lack of legal foundation puts your equity, invoices, intellectual property, confidential information, and investor relations at stake. Today, we'll cover 4 key areas: a cautionary tale about a co-founder breakup, a contract-by-contract breakdown of 5 essential agreements, an overview of template resources, and red flags to watch for when signing contracts. We begin with Chapter 1, the co-founder breakup story. Before diving into the contracts themselves, let's explore why they matter through the lens of a common and painful startup disaster. In this story, 2 founders with a verbal agreement faced a crisis when one decided to leave 6 months before a seed round. Without a vesting schedule, the departing founder walked away with 50% of the company. Without a clear operating agreement, the remaining founder had no mechanism to buy back the shares. The company failed. The cost of paperwork would have been minimal, but the loss was everything. The lessons are clear. Vesting protects everyone. Roles must be defined in writing to create accountability. Departure terms for equity must be set beforehand, and investors will look for these agreements during due diligence, as gaps can be deal killers. Welcome to Chapter 2, Contract-by-Contract Breakdown. We will review 5 essential agreements, explaining what each one does, when it applies, and the key provisions to include. Let's go through them one by one. Contract number 1 is the operating agreement for LLCs, or the shareholder agreement for corporations. This document acts as your startup's constitution, defining internal relationships, decision-making, and asset ownership. This is non-negotiable if you have a co-founder. Your operating or shareholder agreement must cover key areas: precise ownership stakes, decision-making processes, transfer restrictions like the right of first refusal, and exit scenarios, including acquisitions, IPOs, or dissolution. Contract number 2 is the co-founder agreement. This document dives deeper into the working relationship between founders. It ensures you answer all the hard questions before you are under pressure to do so. The 4 pillars of a co-founder agreement are equity splits, roles and responsibilities, vesting schedules, and departure terms. Addressing these prevents deadlock, turf wars, and ensures fair handling of unvested equity. Vesting protects you through math. A standard 4-year vesting schedule with a 1-year cliff means 0% vests until month 12, when 25% vests. After the cliff, equity accrues monthly. This aligns incentives, ensuring commitment to the journey, not just the initial idea. Avoid the temptation to split equity 50-50, as this creates permanent deadlock. The better approach is to have the uncomfortable conversation early. Consider who had the idea, who takes financial risk, whose commitment started earlier, and who brings critical skills. Even a 51-49 split creates clear decision-making authority while feeling nearly equal. Contract number 3 is client and customer contracts. Every time you take money from a client, you enter a legal relationship. A written contract defines the terms, protects both sides, and especially protects you from disputes later on. 4 clauses are essential for your client contracts. The scope of work defines what you deliver, preventing scope creep. Payment terms specify when and how you get paid, including late fees. IP ownership determines who owns the work, and the limitation of liability caps your financial exposure if something goes wrong. IP ownership is the clause most founders get wrong. If your contract lacks a clear IP assignment clause, a contractor may claim ownership of the work. Good language explicitly states that work product is, quote, work for hire, or is assigned to the company. Contract number 4 is independent contractor agreements. While hiring contractors seems simple, without a proper agreement, you risk worker misclassification, IP disputes, and tax liability, which can be deal killers during fundraising. You can't just pay someone and call it done. Risks include misclassification, the IP ownership gap, confidentiality exposure, and due diligence flags. Investors and acquirers will audit all contractor relationships, so having solid agreements is crucial. A solid contractor agreement must include relationship designation, explicitly stating the worker is a contractor, not an employee. It also requires clear scope and deliverables, precise IP assignment language, and a non-solicitation clause to protect your employees and clients. Many states use the ABC test to determine worker classification. All three factors of the test must be satisfied for someone to legally qualify as an independent contractor. If your arrangement fails any part of the test, you may be required to treat the person as an employee. Contract number 5 is non-disclosure agreements, or NDAs. NDAs are often misunderstood and are both overused and skipped when they are actually essential. Knowing when they matter is a critical founder skill. Use an NDA when sharing proprietary technology, entering partnership talks, or hiring contractors who will see unreleased products. Skip the NDA when pitching to VCs, discussing general business concepts, or during early customer discovery. Asking a VC to sign one is often seen as a red flag. A solid NDA clearly defines confidential information. It outlines the obligations of the receiving party, specifies exclusions for non-confidential information, and includes the term and termination of the agreement, as well as the remedies for breach. NDAs can be one-way or mutual. A one-way NDA is used when only you are sharing confidential information. A mutual NDA is used when both parties will disclose sensitive details, which is common in partnership talks or M&A discussions. Default to one-way unless a mutual exchange is genuinely warranted. Welcome to Chapter 3, Where to Get Solid Legal Templates. You do not need to pay an hourly rate for every agreement. A growing ecosystem of founder-friendly legal resources offers high-quality, battle-tested templates, many of which are free. The best template sources include Clerky for tech startups, bond terms for standardized commercial contracts, Series C documents for financing, and NVCA model docs for Series A and beyond. Other valuable resources include YC's SAFE for pre-seed investing, law school clinics for low-cost legal help, Stripe Atlas docs for incorporation templates, and the Founder Shield and Clerky blogs for clause explanations. How do you decide between a template and an attorney? Use a reputable template for standard situations, like basic NDAs and contractor agreements. Consult an attorney when stakes are high or the situation is unusual, such as a large deal or complex long-term obligations. Always hire an attorney for your initial incorporation, any institutional financing rounds, and any deal over $250,000. Templates are generally fine for standard contractor agreements under $50,000 or basic client service agreements. Finding affordable legal help is possible. Ask other founders for referrals to experienced startup attorneys. Negotiate deferred fees until your seed round closes, which many startup firms offer. Also, use fixed-fee engagements for defined scopes of work to remove billing uncertainty. Welcome to Chapter 4, Red Flags when Signing Someone Else's Contract. Eventually, you will receive a contract drafted by another party. Since the drafting party writes the contract in their favor, you need to know what to look for to protect your business interests. Watch out for clauses that should make you pause. Unlimited liability is a major red flag. Always negotiate a liability cap. Broad IP assignment can claim work done on your own time. Unilateral amendment rights allow the other party to change terms without notice. Mandatory arbitration with a class waiver requires resolving disputes privately and waiving class action rights. Other flags include auto-renewal without notice, exclusivity without compensation, and governing law in a distant state. Also clarify vague terms like reasonable efforts. When you spot a red flag, respond professionally. First, flag it by identifying the clause and its specific risk. Second, negotiate it by requesting a clear change or deletion. Third, escalate it by bringing in an attorney for high-stakes terms. Most reasonable counterparties expect negotiation. Here is a simple negotiation script. Specify the section and requested change, limit liability to standard terms, and state that the request is standard. This approach is specific, professional, normalized, and open to dialogue. Let's review your 5-contract checklist. You need 5 core contracts, a 4-year vesting period with a 1-year cliff, and remember that many best-in-class legal templates are free. The 5 essential contracts are the operating or shareholder agreement and the co-founder agreement, which should be done first. The client contract and independent contractor agreement are needed before the first paid work or hire. The NDA is situational. Avoid common founder mistakes. Don't wait until there's a problem. Get contracts in place early. Use founder-specific templates, not generic consumer ones. Never sign without reading. And remember to update your agreements as the business scales. Legal hygiene saves deals. Clean documentation affects whether deals close and at what valuation. Maintain a clean cap table. Ensure all IP is assigned to the company. Keep all contracts accessible. And avoid oral agreements for material commitments. Here is a prioritized action plan. Step 1. Incorporate properly. Step 2. Lock in the co-founder agreement. Step 3. Set up your contractor template. Step 4. Create your client contract. Step 5. Build your NDA library. To recap the core principles, verbal agreements will cost you, every contract is negotiable, use templates as a starting point, and legal hygiene compounds over time, making future deals smoother. Key takeaways. Get the 5 essential contracts in place. Vesting protects the company, and excellent free resources are available, such as bond terms and Series Seed docs. For additional resources, check bond terms for open-source commercial contracts, Series Seed for free financing documents, NVCA for model legal documents, and Clerky for paid attorney-vetted incorporation and equity documents.